September 10, 2012. This is Justice done dirt cheap at the Justice Building, Fredericton, New Brunswick. Just want to point out the police presence downtown for whatever reason. There's a Fredericton Police Force car over there, and then another one ahead of us. Now, I was just at a hearing where all that was basically done at this point was a decision by Justice Judy Clendenning. Justice Judy Clendenning ordered me to pay $5,000 as security for costs so that I may have an appeal heard. Now, the normal process of things is that one files. I'll show you the second police car there. Oh, actually, that one's an RCMP car. Interesting. In the city of Fredericton. Alright, so what it was is I have to pay $5,000 as security for costs so that I may have my appeal heard. Now, the normal due process of things is that someone gets a decision that they're not happy with, they believe there's an error in fact, error in law, or abuse of discretion occurred, one has the right to appeal that decision. Now, my right to appeal is being impeded by having to appear for this motion, prepare for this motion, and now the judge has ordered in favor of the city of Fredericton. We're looking at City Hall right now for the city of Fredericton, and just to give you a little backstory here, the reason why this action is ongoing in the first place is in 2008, the City of Fredericton Police Force members basically dragged me off my bicycle, slammed me on the trunk of a car, assaulted, battered, arrested me, detained me for some time, and I noticed when I was being arrested that there was someone sitting in the passenger seat of a unmarked police car behind me. Now, who that person was Trina Rogers. Now, when I filed the Right to Information and Protection of Privacy request, I found out that the reason why the Fredericton Police Force arrived that day and basically arrested me was because someone informed the police that there was something or other illegal going on and gave my description. That's why the police came after me. Now, a second event occurred where I was simply shoveling my driveway. Fredericton Police Force arrived, swept my feet out from under me, started using all sorts of pain compliance techniques, pepper sprayed me, and arrested me, held me for some time, then released me without charge. Now, the reason why they did that was, and I found this out through the Right to Information and Protection of Privacy Act in New Brunswick, is they appeared on the scene that day because someone called the police, explained there's something or other going on, and the Fredericton Police Force had to apprehend a wanted criminal. So if it wasn't for someone calling the police and giving fraudulent misrepresentations, the police would never have arrived, and I wouldn't have experienced all the injuries I did that day. It took months of recovery before I was even able to use my hands half decently again, and to this day I have injuries that are not healed. So because of those two incidents, I combined them two into one action against the city of Fredericton and all the relevant police force members, and also Neil and Trina Rogers were named as defendants because I believe they were the ones who were calling the police and causing me the problems in the way they have. And this is not just two incidents. I mean, this has been over the past 6 years. There's been hundreds of calls to the Fredericton Police Force that have resulted in the Fredericton Police Force arriving at my property, and if I wasn't inside quick enough, I would basically get dragged off by the police department. Most of the time I made it in fast enough and there wasn't an incident because of acting defensively. But anyway, what's relevant here is the Justice Judy Clendenning heard a motion by the city of Fredericton which basically said they wanted the matter dismissed for various reasons. Neil and Trina Rogers filed a motion as well that parroted everything that was said by the city, They basically took the exact same wording and just filled in their own names with instead of the names of the other defendants that Leanne Murray was representing. So they did not actually research or do anything additionally other than copy and paste a motion that was filed by the city. I filed a motion for an extension of time to file and serve the parties and joinder of parties because of some various technical issues I was trying to overcome regarding this litigation. The decision that was rendered was my action, the entirety of my statement of claim and amended statement of claim was struck, which was the originating document starting the action against the city. Now with the entirety of the claim struck, there's nothing further to move forward with. So I appealed that decision because not only was the decision wrong in striking my claims, and anyone reading her decision, I'll post a link to the decision online, can read that Justice Judy Clendening claims that the claims I made are incomprehensible, illegible, all this stuff. And when anyone reading it can read, well, the Fredericton police force arrived on a certain day, they did certain things to me, it's considered assault or battery, and it's lots of detail there of what exactly occurred. Anyways, I decided to appeal that decision, which I filed all the paperwork, and we're pending appeal right now. In the meantime, the city of Fredericton had Leanne Murray as their solicitor file a motion for security of costs, so that I have to pay before going to appeal. In case, this is just in case the city wins the appeal. Now what's interesting is the matter has not been decided yet. We're still waiting for the appeal hearing, and a court of appeal is the one that's going to decide whether Justice Judy Clendening's decision was correct or not, and the cost orders were correct or not, because Justice Judy Clendening ordered over $10,000 cost against me on those series of 4 motions that only took 2 hours to hear, which was not enough time to hear 4 motions of that magnitude. So today was the hearing. This morning at 9:30 was the hearing for the security of cost motions filed by the city. The Neil and Trina Rogers both appeared at the hearing. I demanded that the court order them to be removed from the courtroom immediately because they're harassing me. There's no reason for them to be there. They're not part of the motions that were heard that day. They're not actually moving parties, nor are they joined in those motions. And these people, Neil and Trina Rogers, have petitioned the courts. Well, what they did is they filed a complaint and provided statements to the Fredericton Police Force, who then charged me with assault and had to sign an undertaking to basically stay away from Neil and Trina Rogers. They claim to be in fear of me, that they're fearful of me, and so there needs to be this undertaking provided. Now, what shows that is totally contradictory is today they appear at a hearing, totally unafraid to appear and have no reason to be there other than to just harass me. Now, this is not the first time that they've appeared at hearings that had nothing to do with them. There's another Court of Appeal hearing that's noteworthy, where in the decision itself, the court even notes that I demanded they be removed from the courtroom, and the court refused. The Court of Appeal refused to have them removed at that time, and on that day they were following me around. Whenever there was a recess, I would step outside the courtroom to either have some refreshments or use the telephone, and they'd follow me around, eavesdropping on my conversations. I mean, this is harassment, stalking. I mean, these are 2 criminal charges that these people are engaged in criminal behavior, yet they're the ones who had me charged with assault and have me subject to this undertaking. Now, the judge refused to order them to be removed or to even ask them to leave. And I know that a judge can order people to be removed from a hearing, because I've been physically dragged out of court hearings where if I'm saying something the judge doesn't like, I can be dragged out, and I have been dragged out by the heels. The judge just orders the sheriffs to remove someone, and the sheriffs do that. They physically drag you out of the courtroom. So the judge refused to do what she had the power, jurisdiction, and authority to do, to control her own process and the process of the courtroom, and refused to do that for me. It's wrong. Not only that, the Neil Rogers tried to include an affidavit with the court record, which was never served on me. Now they tried to just move this thing along where they wanted part of the record without actually following the correct legal procedure, and only because I recognized that I don't know anything about this affidavit, and I questioned whether it was even served, and it was admitted that it was never served. So I demand to be struck from the record immediately, and the judge, instead of just striking it, which is the correct thing to do, actually ordered a recess so that I could read it over before deciding what to do with this unserved affidavit. After the recess, the city of Fredericton said they wanted to withdraw the affidavit, and they claimed that Neil Rogers agreed to withdraw the affidavit. Now what's amazing to me is it doesn't matter whether Neil Rogers agrees to withdraw the affidavit or the city agrees to withdraw the affidavit. It should be struck as a matter of just process. It was never served. So if they want to use it, they would have to have an adjournment and properly serve the document on me, but instead they make out as in they're deciding to withdraw it. Anyways, the hearing was quite amazing. There was double speak happening that is just hard to wrap one's mind around. On the one hand, the city of Fredericton said they have no evidence that I can't afford to pay, and they presented no evidence that they presented no evidence that I can't afford to pay, nor do they present evidence that I will refuse to pay afterwards. So they're saying on the one hand that I have plenty of wealth and money to pursue lots of court actions. They're saying on the one hand I have lots of money, and on the other I don't have enough money in their eyes for them to be compensated. So what's interesting is you cannot have your cake and eat it too. You can't say someone is poor and rich at the same time. It's either one or the other. And they presented no evidence that I am either poor or rich. And it's up to them to be able to prove to the judge that either I'm too poor to pay, and that's why they need to have costs paid beforehand to make sure that they get paid in the end, if they're ultimately successful. Or on the other hand, if I'm too poor to pay, then jurisprudence on subject says that that should not be a bar for me having an appeal heard. So lots of contradictory things being said today in court. Lots of strange procedures, strange practice. And finally the decision was rendered, which I don't agree with. I believe it's based again in errors in fact, errors in law, and abuse of discretion. It's claimed that this is a discretionary decision for the judge to order costs as security in these circumstances, and I believe there's not enough facts to support that decision. And what does one do when they're not happy with a Court of Queen's Bench decision? They file leave to appeal or an appeal. In this case, it's a final decision, because if I don't pay $5,000 to the city of Fredericton within 30 days, it's deemed that my appeal is abandoned, and the lower court matter of the damages that the city of Fredericton have done to me would be stayed. So that lower court action stayed, and the appeal is deemed abandoned. Now, it's wrong that I'm put in a position like this, because if I don't want to pay the $5,000 out of principle, it doesn't mean that there's no merit to my action, and it's wrong that this is brought up as a bar to me moving forward to appeal. So we can always appeal this decision and see how it goes to the Court of Appeal of New Brunswick. Thank you for listening. It's Justice Dunder Cheap in Fredericton, New Brunswick. I wish you a great day. Thank you for listening.